This is a changing environment, and the not-for-profit corporations are now becoming more and more the focal point of our livelihood. I mean, it's one out of every 20% of our workforce, private workforce, works for a not-for-profit. In New York, not-for-profits make $200 billion a year, more than any other state in the union, revenues. We have had instances of total lack of control with not-for-profit corporations. The scandals, I put in something yesterday just to reinforce it. It's called Charity Watch, and it's called the Hall of Shame. And it shows, you know, the United Way of America, Smithsonian Institute, Adelphi College. These were charitable institutions with blue ribbon board of directors that were absolutely run amok. You had one with Smithsonian where he was, the CEO was running around. He had a young girlfriend, chauffeur driven. They bought an apartment on the budget. It just went on forever. He was indicted and put in jail. But I'm saying there's been a history of things that have raised the level of consciousness of board performance, and you've seen the ones that Jim pointed out earlier. So what we have is more and more of an awareness of the importance of not-for-profits and the need for management to get involved, the need for the board to get involved and supervise management. Recently, there was a Leamington home for the agent, a nursing home in Pittsburgh, which was so badly mismanaged that they didn't claim Medicare benefits when they could have. They had every regulator criticizing the way they were conducting business, and the board was just absolutely boneheaded about it. And the creditors sued because the company went under, and they received something like $2.25 million in damages and $1.25 million punitive damages against the officers. That's the kind of setting that is not good. So what can you do? What we try to do is to encourage limiting the exposure of a director. And there's an emphasis, I think, on, we talked about it, on recruiting directors with the right skill sets. That's important. And then you had really a knockout decision in Caremark International, which was a Delaware case, but what happened was Caremark sold health services. There were convictions for violating anti-referral laws. The company lost millions of dollars in the process, and the directors were sued for mismanagement. But the court said, no, the directors are okay. It said the directors have a duty to be reasonably informed concerning the corporation, assuring themselves that information and reporting systems exist in the organization that are reasonably designed to provide to senior management and to the board itself timely, accurate information sufficient to allow management and the board to reach informed judgments concerning the corporation's compliance with law and with its business performance. And this board had put in such systems. Can it misfire? It misfired. I mean, I thought Jim wrote this thing here. And it was, I mean, it's talking about putting in systems, legal compliance systems, financial controls. Now, right after that case, everybody went and they said, let's put in a code of ethics that says we are a wonderful corporation, we don't violate any laws, and we run our first-class operation. That's not what we mean. We mean the company should, at the board level, make sure there's a meaningful compliance program. Analyze your corporation's risk profile, because it's going to be different from corporation to corporation. Education, corporations have problems with regulations dealing with student financial aid. They have student dorms problems lately. They're going to have financial problems in the future. Healthcare, it might be HIPAA, it might be patient safety. Every different organization has certain risks. So what you want to do is have a system that addresses those risks for your corporation and build a program that responds to that risk profile. And you know what? It should be run by a high-ranking officer. If you put somebody way down on the tier in charge of compliance, it says volumes about what you think about compliance. So you want to put this up at the top. And you want to communicate it continuously to your employees. You want to educate them as to what they should be doing. You want to monitor their compliance, discipline them when they break the rules, and reward compliance. And you should have reporting systems that work. Part of that should be a crisis management program, which I would refer to in Perlman's situation. Okay, you have some protection in New York under this limited exculpation for volunteer directors and officers. I think that doesn't really amount to a row of beans. It only applies to third-party suits. If you're being sued for mismanagement or violating the corporation, or the Attorney General sues you, it's of no utility. It doesn't apply for gross negligence or intentional harm. And why would somebody be suing a board member? I try to think of an example. I'm thinking, okay, there's an emergency board meeting. I'm rushing to it in my car. I'm listening to the Bills football game. I get distracted for a moment, and I knock off a couple pedestrians. Now, does that mean I'm immune? I don't know. I don't think I'm going to get away with that, you know? So I don't look to the volunteer statute for much of anything. And I've got to do a lot in a very short time, so bear with me. There's a statute in New York for indemnification of officers and directors. It has a wealth of procedures and information, but what it is the right that you have to your corporation to say, I should be indemnified, I'm being sued, or I'm being prosecuted, okay? Be aware of the fact that it's not generally self-executing. You should take your bylaws and put in there indemnification provisions that make sense. And I want to tell you, I have seen horrible indemnification provisions. One of them says, we will indemnify the directors, officers, employees, and agents to the maximum extent permitted by law. You know, I'm counsel, I'm an agent. Do you really want to indemnify me or my insurance broker? You know, you don't want to put a clause like that. And then if you say you're going to indemnify them to the maximum extent permitted by law, what about the biggest area of concern when you're sued is having money that you don't have to take out of your pocket. You want to go to the corporation and say, float me a loan to defend myself, or these are called advances. And so you want to have protection that you will get advances if you are sued as a director, just black and white. I give you my IOU to pay it back if it's determined I'm not entitled to it, but you advance me the money.
Is that allowed?
That's allowed. That's permitted under the law. Now, there are some, I don't want to use the word zealot because I know where it comes from. There are some people that are trying to say, you know, we shouldn't let somebody get an advance unless they secure it, like with a mortgage on their house or a surety bond and all that. That would be, to my mind, a real tragic mistake to the law, and I don't think that's going to go. There's another area called indemnification agreements, and again, we're coming close. They're widely used in for-profit corporations. They're an agreement between the director and the company. It says the company will indemnify me to in all these instances wherever I have a right to indemnification. It will build in presumptions. It's going to say, I'm presumed to be entitled to the money to indemnification unless I'm proved not to be by clear and convincing evidence. It puts time limits on when you get an advance, and basically it ties the corporation up. Will it become a part of the not-for-profit defense for directors? I don't know, but it's mostly used with other corporations. Then I want to talk about the last item in 1.5 seconds, D&O insurance, which Jim was referring to. Most of the larger not-for-profits buy D&O insurance. That protects the corporation when it indemnifies you. It protects you when you're not indemnified by the corporation. All I can tell you is this. People like you and I get an automobile insurance policy and a home insurance policy, and we throw it in the drawer, and that's my protection drawer, okay? Don't do that with D&O policies. D&O policies can be negotiable. There are a lot of provisions in D&O policies that are exclusions that you might be able to whittle down, and like there's insured versus insured exclusion. That means if one director sues another director to try and get funds for the corporation, it's not covered. But now, if the Attorney General sues the corporation, or a receiver in a bankruptcy sues the director, you might lose coverage unless you have that language modified in your D&O policy. So some brokers are very well attuned to what you need, but there's always room for improving the policy coverage. And it is something you should insist on with the when you're serving on a company that's large enough to afford it. Now, to end this all, you know, the not-for-profit world is so important. I am stunned when I see, I went to a dinner in honor of the nuns and all the institutions that they spawned in New York, from the health systems to the homes for the aged, and you look at the Knox Museum, and you've got all these foundations around, and all of you are you're working for the good of the area, and it enriches our community. And what Jim said in the beginning is really true. This whole program is to say to you, we think you're doing such great work, and we just want you to be able to do it better and in a more informed fashion. And you've been just unbelievably attentive, and we thank you for your attention. That's all I have. Okay. We're done.